I caught myself the other day using a lot of legal jargon, and I'm going to explain one of them to you today. Client asks, well, what's the next step? And I said, well, we're waiting for discovery. Now, what the hell does waiting for discovery mean to somebody that doesn't play in the criminal defense sandbox? Well, what that means is that in Florida, we are entitled to have a fair fight and a fair trial where each side knows what the other side potentially could present to the jury. And when I start a criminal case, I demand discovery up front, meaning I demand every sworn statement, police report, body cam, 911, lab report from FDLE, expert report, every witness they talk to, every recording, you name it. That is called discovery. It's a process of discovery, and it's ongoing. We get like a tsunami of information as a defense attorney when we first get hired. I mean, it can take a couple months for them to turn it over, of course. We're not really entitled to discovery until the state files formal charges. So sometimes you'll get arrested. I'll demand discovery, but I'm not going to get it until they decide, yeah, we're going to file charges. Then I get it. And even then, it can take a little while. But the point is, we are going to have a fair fight on this. I am going to disclose whatever I want to use at trial. They are going to disclose everything, and because the burden is on them, not on us. And discovery is not just all those reports that I'm going to demand and get up front. I get to do depositions as well on felony cases, sometimes on misdemeanor. And depositions, that's another fancy term for I sit at a table with a witness, they raise their right hand, and I start asking them a bunch of questions. What do you know about this case? That's a deposition. We write it down, and then there's no surprise at trial. When they show up and maybe they didn't do a sworn statement, maybe they did, and maybe their deposition differs from what they said at the scene, and maybe it even differs again what they say at trial. That's part of the discovery process, those depositions. The state has really pretty high obligations to supply us everything, even supply us stuff that hurts their case. We call that Brady material. It's exculpatory evidence. You cannot, as a prosecutor, hide the ball on us. If you have some good stuff that would help us, you've got to turn it over. We call it Brady material. In the end, look, the discovery process is designed so that we have a fair fight. There will be no trial by an ambush here, no surprises. Everybody knows what's on the other side, what could be presented, and we know what we're going to say in response to that. That's a fair fight. That's what the discovery process is trying to get us to.